I'm Matt Gishard, and this is No Holds Barred. In today's episode, we're going to talk about criminal threats. What's criminal threats? Criminal threats. I'm going to go back and say when I was a prosecutor, not too long ago, we had something that was called terrorist threat. It's actually Penal Code Section 422, and it is now called criminal threat rather than terrorist threat. And what is that section? What does it talk about? It is where a person willfully threatens to commit a crime which will result in death or great bodily injury to another effectively. So instead of going on and on with, I want to go right to the jury instruction on criminal threat. Why it's important now is because we're hearing about criminal threats regularly, threatening somebody that you're going to kill them and having the present ability to do it. So in the old days, we used to call that's an assault. That means threatening somebody with the present ability to carry out that threat, and the person who received the threat understood it was a threat and was concerned about it, and that's kind of what an assault is. Now we've come up with this new criminal threat, and it's something that people have to be very, very careful about because it's a very serious felony offense. It's not a misdemeanor assault. It's a felony offense to make this kind of a threat. And so from Penal Code Section 422. And let's just talk a little bit about threatening, stalking, or terrorizing. That is what the criminal threat, when they talk about it in the jury instruction, it's under that category. So I'm just going to read to you what the jury would hear. The defendant is charged in count whatever with having made a criminal threat in violation of Penal Code Section 422. To prove that the defendant is guilty of this crime, the people must prove the defendant willfully threatened to unlawfully kill or unlawfully cause great bodily injury to the victim or members of the victim's family. The defendant made the threat orally or in writing or electronic communication or in person. The defendant intended that the statement be understood as a threat and that it was communicated to the victim. And the defendant intended that the statement be understood as a threat. Under the circumstances, the threat was so clear, immediate, and unconditional and specific that it communicated to the victim a serious intention and the immediate prospect that the threat would be carried out. And the threat actually caused the victim to sustain fear for his or her own safety or his immediate family, and on and on and on. So there's more to that instruction, but I wanted to read that instruction because I think it's important, and we do it in No Holds Barred. We actually read the jury instructions. That's actually the law in a case at trial that the jury hears, and it's the law which they put together with the facts that they've heard from evidence coming in and reach a decision. So we'll go back to that. A person willfully threatens to commit a crime which will result in death or great bodily injury. So we often think about that road rage incident that we've heard about. Person jumps out of the car with a gun, or let's say a tire iron or a knife or anything, and is in a rage and threatens to kill or beat up another person. The other person then hears that threat and is in fear of the threat, as one would rightfully be, and that becomes a terrorist threat. So another example is a person I'm familiar with who was drinking late at night, acting stupidly, and called up a person that he did business with, threatened to come over and kill him, told him that he had a gun, was going to come over and kill him, and the person had the apprehension that he was actually going to do this and called the police. And the person I'm familiar with found himself facing a knock on his door, being arrested, and having a $50,000 bond for making, at the time, a terrorist threat. So you want to be very, very careful. So that telephone call late at night. Now understand, you can also do it by text or email, and you're going to kill somebody's kids, you're going to kill your parents, you're going to do whatever. So the idea is, when you make a terrorist threat, you make that threat, and you may not have the ability to carry it out. It doesn't matter. If you make it, and the apprehension is you have the ability to carry it out, and the victim believes that, in fact, you can carry it out, and they believe your threat, it's a terrorist threat. It's a felony. So I want people to be very careful, because we read so much nowadays about road rage incidents or incidents with neighbors, and these fears have been elevated to the extent that the legislature has now made it a crime, and not just a regular crime, a very, very serious crime. So, of course, the moral of the story is, don't threaten to kill somebody or commit an assault or threaten them with great bodily injury or anything. Don't do that. The only case in which I believe you can lawfully do that is a lawful case of self-defense, where you tell somebody, if you try to kill me, I'm going to kill you. I have a gun, whatever. But just out of the blue, because you're having an argument, or you're in a road rage incident, or you don't like somebody, or there's a civil dispute that you have, keep in mind, you make that criminal threat, and think of what I indicated to you in the jury instruction. You make it however you make it, by text, by phone, however, you're committing a crime. Don't do it. Now, people often say, well, I was drunk. And I want to go back to my training as a prosecutor. When I started out, we did lots of DUIs, and there's a jury instruction on voluntary intoxication. So voluntary intoxication is not a defense to an act. It's not a defense to drunk driving. It's not an offense to a criminal threat. It's not a defense to stalking. It's not a defense to anything. The only time that voluntary intoxication can be a defense is if somebody is unconscious. That means they are so intoxicated that they obviously don't know what they're doing. But in these cases, in that case I'm familiar with, the person, it was voluntary intoxication, made the statement willingly and knowingly, even though they were intoxicated, and there is no defense to that. Because in that case, I understood that was his defense. Well, I was intoxicated. And I often laugh and say, and I used to say, the person who makes statements and dances around at the party with the lampshade on their head meant to do that. The intoxication, their inhibitions went away, and they were able to put that lampshade on their head. So the people that have voluntary intoxication, they're intoxicated, they make statements, they dance with the lampshade on their head, or they make threatening criminal threats. They don't get to say, well, I was intoxicated. And if the other side has taken that threat as a real threat, and there was actually the ability to carry it out, we have a criminal threat. That's the last thing you want to do. So let's be cautious. Let's be cautious about what we send in emails. Let's be cautious about what we do. And again, I'll say, if you don't want somebody to see it, don't hit send. I hope you appreciate this information on this episode of No Holds Barred on criminal threats. If you like it, if you have a comment, put it in the chat, put it in the question. hit like, hit subscribe, and we'll see you at our next episode of No Holds Barred.